Well, hello, everybody. Okay, so what I'm going to do today, there's been a lot going on in the Chad Daybell and Lori Vallow case. Today, I am going to do part one of a three-part series of filings from John Pryor for Chad Daybell. Now, the first couple are two orders that were made by the judge. They'll be pretty quick. There's also a motion to appear. That one will go pretty quick. And then we have a motion for a bill. That one is a little bit lengthy. So we'll do that one today too. And then part two is going to be the motion to sever that John Pryor has filed. It's quite lengthy, so I'll do a separate video for that. And then we've got a motion to continue, which was filed by John Pryor for Chad Daybell, and I will do a separate video for that. So it's going to be a three-part series here. There's a lot to go over, and after reading through these documents, it's very telling the position that John Pryor and Chad Daybell are taking. Okay, so I think that you guys are going to see a lot of what is going to be expected at this trial. I do think that Chad has turned on Lori. I've said that right from the beginning that I believe that he was going to turn on her. So I do believe there's trouble in paradise here. And then I think I'll put out part one of Chad's stuff today, and maybe later today or tomorrow I will put out Lori's motions that have been filed. Now there's only one part to Lori's. It's all going to be in one sitting. It's lengthy, but there's a motion regarding the death penalty. They are putting up a fight, and there's a lot in there that you're going to see what their position is compared to what Chad's position is. I very much think that Lori's still very much in love, and she thinks everything is honky-dory with her and Chad. You're going to see that with how different these motions between Chad's motions and Lori's motions on what's being filed. Now, we've also got to keep in mind here, too, that Chad waived his right to a speedy trial, whereas Lori has not. So that way, the judge did put them together, figuring, okay, well, Lori's speedy trial, she would have had to be heard, the case would have had to be heard by October, but because there's such voluminous information, that putting it off to January so they could have Chad and Lori's trial together wouldn't be putting her out and maybe jeopardizing that speedy trial thing. Well, anything past the date for speedy trial is jeopardizing a reason for appeal on Lori's side. But I guess the courts were willing to take that chance and go ahead and push her trial from October, which is the deadline for her speedy trial, to January, to put it so they can have the trials joined as they were. Now, anything further than that would absolutely give her reason to have her case maybe even dismissed. We don't know what the repercussions of going further than January would cause. But as it stands now, they're both set to go to trial starting January 9th. But I'm going to give you a little sneak. I don't think it's going to happen. And I think that there is a whole boatload of trouble coming for these cases. You're going to see why when you've seen all three parts and then you've seen Lori's. You're going to understand what I'm talking about. I think that both defense teams are playing a game here. Excuse me. As you know, the prosecution wanted to have this trial later on in 2023. Chad Daybell's lawyer said, no, we want this going ahead. We want the trial date for January. Okay. The prosecution wasn't happy with that. They wanted it a little further out, but said that they would make sure that they were ready to go in January to suit what the defendants wanted. I think Chad Daybell's lawyer, John Pryor, how can I say this? I think he pulled the gun when he figured if he said, oh no, we're going in January, we want this in January, maybe forcing the prosecution not to be ready in time, giving them an upper hand, but it backfired on them. Okay. So we will get into that. That will be in, let me just see here. Okay, that will be in the third part. So this first part is going to be the two orders that the judge made. That will be pretty quick. And then there'll be a motion regarding appearance, which is really quick. And then the longest one, it's going to be the motion for the bill of particulars. We're going to do that one today. The next one, part 2, is going to be the motion to sever from the death notice co-defendant. And then the third part is going to be the motion to continue. Okay. Which is going to be interesting. And then we are going to see also what Lori's team has filed, and that's a motion to prevent the death qualification. And for alternative relief. So we're going to get into that. So we'll get through part 1. And then I think we'll do Lori's, and then we'll do part 2, and then part 3 of Chad's. And you're going to see what each team is doing, and it's going to give you some idea about who's turning on who. So with that being said, just give me a second here. Okay, so let's get through these first few pages. They're going to be fairly quick. Okay, so this is the first order that the judge made. You can see the date here on September 23rd. And this is all regarding Chad Daybell. So based on the previous discussion with the parties and in its administrative capacity over this case, the court hereby orders the following order. Counsel are to submit a proposed juror questionnaire conventionally under Idaho rules for electronic filing and service to the court for in-camera review no later than October 14th, 2022 at 5 p.m. So what this means is they want Chad Daybell's lawyers to go over the questionnaire that is going to be presented to the jury to see what jurors they're going to pick. Is there any questions that the defense wants included in that questionnaire, etc. Okay, so you notice that this was sent on the 23rd. Well, once this is sent out, the games begin. Okay, and you're going to see that when we get to the motion for the bill in a bit. So they're now under advisement now that this is going forward. We got to get this jury questionnaire together. We need your input. The court needs your input. Get it to us no later than October 14th. Because as it stands, as of right here, you can see the 9th, the 23rd of 2022, this trial is going ahead. Okay, so let's move on to the next order that was also filed on the 23rd. This is another order by the judge. The defendant filed a motion to change venue on July 21st, 2021. The court granted the motion to change venue, or more apt, granted a transfer of trial on October 10th, 2021. The Idaho Supreme Court entered an order affirming the order of this court to transfer the trial to Ada County. The rationale for granting a transfer of the trial was the deluge of publicity in pretrial reporting about the case. Accordingly, it is hereby ordered pursuant to ICAR 45 AMB and for the reasons set out forth in the memorandum, decision, and order prohibiting video and photographic coverage entered in the co-defendant's case on September 23rd, 2022, the court hereby revokes the authorization of visual coverage in this case consistent with that order. Okay? Okay, so next, this is a motion that the defense filed. You can see that here, John Pryor, on the 28th. Motion to appear in street clothes. Comes now the defendant, Chad Daybell, by and through his undersigned attorney, respectfully moves this court to continue to allow the defendant to appear in a street clothing instead of jail clothing for the court hearings. Defendant has appeared in street clothing in the past, and this motion requests that the court continue to allow this practice to continue until the conclusion of this case. So notice is hereby given that on the 13th day of October at the hour of 9 a.m. or as soon thereafter as counsel may be heard, John Pryor, attorney for the defendant above named, will call up for hearing a hearing for the defendant's motion to appear in street clothes before the Honorable Judge Stephen W. Boyce, District Judge at the Fremont County Courthouse in St. Anthony, Idaho. Motion to appear in street clothes. I don't know why they filed this, you guys, because so far he has been appearing in his street clothes. So I don't know if the jail was refusing to allow him to change into street clothes to go to his hearings, or the court stopped allowing that. I don't know, but he's made a motion, the same as Lori Vallow's lawyers made this same motion for her to be able to appear in street clothes. So next, we are going to jump into this. As you can see, it is 10 pages. I am going to scroll through this and let you guys read it on your own. If there is something in particular I feel that I need to point out, I will unmute myself and I will address that. But this is a motion for a bill of particulars, which means they want to know the ins and outs and why certain things were decided on charges and what is included in the charges, because everything was done by a grand jury indictment, which means they weren't able to be in front of the grand jury to cross-examine any witnesses or any information that was put out. So they want to know exactly why they came to the conclusion that they did upon charging Chad Daybell with what they have. They want to know the particulars of that, how they came to decide that, what were the mitigating factors to decide that, etc. So they know how to properly defend their client. So that's the basic overview here. But there's a lot of information in here too that this gives us. Okay. And it kind of, for somebody who has worked in the judicial system for many, 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 many years, I can see things that maybe normal people, and I'm not saying normal like you guys aren't normal, but people who have not had any legal expertise or experience or anything like that maybe wouldn't catch. Okay. So if there is something in here that I feel like I need to bring attention to, I will unmute myself and I will talk to you about that. And a sneak peek at the part 2 is right here, the motion to sever. Okay, so let's get going with this one, you guys. Let me make this as big as I can so you guys can see it. And we will go through this starting now. Okay. So there is a section, and it's going to be all of this here. Whoops. I don't know why it's doing that. Usually it just follows. Okay, so where it says here, there are allegations of grand theft and conspiracy to commit grand theft. There are at least 2 co-conspirators, one of which has been named in the indictment. There are known unnamed co-conspirators as well as unknown co-conspirators, according to the indictment. So, what does that mean? That means that the grand jury discussed other people that may have been involved in this, but are unknown to the defense because their names were not given in what they received. So to the defense, as far as John Pryor, they are unknown. So they want the names for those people. This also I see as being a problem. The defense has a significant amount of discovery, and as of this date, there is still a significant amount of discovery that has not been provided to the defense. Is this going to end up like the Barry Morphew trial, that they don't have all the discovery that they need? I don't know. And they're making a point of saying it again here. Okay, much of the discovery has been gathered over several years, and the defense is in the position of sorting through all the discovery which the prosecution has had in some instances for years. A bill of particulars would narrow down the possible alternative. I can't talk today, you guys. Theories that Mr. Daybell would be required to defend against. Okay, this here is also something else that I feel could be detrimental. He's also saying that it's also needed to avoid unfair surprise at trial. A further purpose of the bill of particulars: under the current indictment, the government could change their theory under which it is alleging murder or conspiracy at its whim between now and trial or during the trial itself, posing a grave danger of unfair surprise. So what that means is, by the way that the charges are written, because they don't know all the particulars of what the grand jury had to make their rulings on such things, they could be grouping a whole bunch of things together. And what they're saying is, we don't know what they used to make that decision to have him charged with what he's charged with. So they want to know that. So that's all they can use in the prosecution's case when they're prosecuting this at trial. Okay, they want to know what's going to be coming out at trial. And what this says, with them not having all the information, if the prosecution at any time feels like it's not going in their favor, they can jump ship on the theory that they were going with and change their theory, unbeknownst to the defense. I feel this is a mistake. This is Chad's lawyers writing this. The defendant should have the right to defend himself and face her accusers. Well, I don't know, maybe he's both now. I don't know. But this is, I don't like this. And you guys know I point this out every time. I don't like this when you're typing up court documents and you make mistakes like this. Now, as you see here, they name, okay, the conspiracy to take the life of Tylee and to commit theft of her monies by deception between and among Chad, Lori, and Alex, and other co-conspirators, both known and unknown. That's interesting. And like I said, in these filings, we get to see a little bit more about what is actually going on that we have not been privy to in the past. So this is telling us there's also other co-conspirators, both known and unknown. Okay. And this is between the dates of October 26, 2018 and continuing until January 15, 2020. In the county of Madison, state of Idaho, and elsewhere, including Fremont. So this is interesting, you guys. Like I said, as we go through all these, and this is why I'm going to do this in 3 parts, so it gives you guys a little bit of a break to absorb what you're hearing here, because you're going to see a lot of things like this in part 2. A lot more information is coming out that till today has been sealed. So we're getting tidbits of information that we wouldn't otherwise get. And this is what they're claiming again. They need to know who they are claiming did what. And they're saying it's too vague. Now, read this. This is going to be very interesting right here. The government has failed to identify indispensable parties, those being co-conspirators, as well as defining which, particularly using plain, concise, and definite statements of the facts, dates, and events this alleged conspiracy occurred on or between. The language in the indictment describes sometime between October 2018 and January 2020. And this is some of the wording that they're complaining about. Sometime. They want exact dates. The government has further failed to identify where within the 1,369 square mile area of Madison and Fremont counties these alleged conspiracy occurred, not to mention the elsewhere language, which is alleged to have occurred. The defense assumes somewhere within the state of Idaho. They're saying it's too vague. Okay, so just read through this, you guys, because this is giving us a little bit more information. The indictment states that Chad Daybell endorsed and espoused religious beliefs for the purpose of encouraging and or justifying the homicide of Tylee Ryan. So they want plain, concise, and definite written statement outlining the specific facts that the government is relying upon to support that allegation. The defense has seen nothing in discovery this far which would support Chad Daybell's religious beliefs, either encouraging or justifying the homicide of Tylee Ryan. This also is very telling of what is going on behind the scenes, because you can see as to count 2 of the indictment, the government alleges that on or between the 8th and 9th of September in the county of Madison, state of Ohio, both Chad Daybell and Lori Daybell were concerned in the commission of first-degree murder and did aid and abet in its commission, or not being present, advised and encouraged its commission, or by command compelled another to commit the crime and did so with malice and forethought. Are they going to try and blame Alex? Again, here the same. And again, the same here. The defense requires a plain, concise, and definite written statement outlining the specific facts that the government is relying upon to support the allegation that Chad Daybell advised and encouraged some unnamed person or persons to commit the crime of first-degree murder. Also, the defense would like to know the identity, of the unnamed person or persons, as well as their address, so the defense can investigate the allegation. So they're saying that there's somebody else too, you guys. It's more of the same here. And the defense wants to know the identity. Okay. As to count 3 of the indictment, the government's lawyers claim that there was an alleged conspiracy to take the life of Joshua Jackson Vallow, hereinafter referred to as J.J. Vallow, and to commit grand theft of his monies by deception between and among Chad, Lori, and Alex Cox, and other conspirators, both known and unknown, on or between the dates of October 26, 2018, and continuing until January 15, 2020. While the government is permitted to speculate as to the means of how the crime was committed, they are not permitted to speculate as to the specific actors or be so vague in their description of the event as to make the defense prepare for every possible scenario in every portion of the state of Idaho. So they're saying the government has failed to identify indispensable parties, those being co-conspirators in the violation of Brady versus Maryland. The government is to define with particularity, using plain, concise, and definite statements of the facts, dates, and events this alleged conspiracy occurred on or between. The language in the indictment describes sometime between October 18th and January 2020. The government has further failed to identify where within the 1,369 square mile area of Madison and Fremont counties this alleged conspiracy occurred, not to mention the elsewhere language, which is alleged to have occurred, the defense assumes, somewhere within the state of Idaho. So they want the government to be required to outline with particularity any fact that supports the conspiracy theories. The indictment states that Chad Daybell endorsed and espoused religious beliefs for the purpose of encouraging and or justifying the homicide of JJ. And they're going to basically say the same thing again as what they did in what we just read in Tylee's. And again, he's going to ask for clarification on all of this, just like they did in the charges regarding JJ and Tylee. But we're also seeing that Alex Cox is involved in this, and so is Lori in the death of Tammy. So, for the reasons stated above, the defendant Chad Daybell requests this honorable court issue an order for bill of particulars consistent with the motion set forth above. So he wants to see everything in plain, concise, and definite written order outlining specific facts that support each one of these charges and not all the charges grouped together, including the fraud and everything else. So he is intending to bring this up on October 13th. Okay, so that is what we have for part one. Part two, like I said, is going to be the motion to sever from the death notice co-defendant and then the motion to continue the trial. So we will be going over those in part 2 and 3 because they are very lengthy. They're over 30 pages long. Again, I will go through it like I have here. Stopping to give you guys some information because I know a lot of yous are asking, well, what does that mean? What does this mean? So I will go over it. You can pause it and read it at your leisure. And and we will see what's going on. I think the next one that I am going to release after this is going to be Lori Vallow. Okay. Lori Vallow filed, her lawyers followed a motion to prevent the death qualification of the jury or for alternative relief. That's what we will be going over next in the next video. And then we will pick up on part 2 and then part 3 of what Chad has filed. Okay. So until the next time, you guys, please take care of yourselves. Please stay safe. Love you to the moon and back. Bye-bye for now.